Yeah, critical ತಿಂಗಳು ಸಂಬಳ. My lords, if I may move a memo for being spoken to, my lords. My lords, it's just type that they'll petition shall provide maintenance of 20,000 per month from the date of the petition in so and so till today. However, you had dictated that it should be paid from the date of the order, my lords. So it may be
Monday.
not today.
MFA filed an IA for withdrawal of amount.
MFA.
Please, madam.
Little less it on Monday.
Monday.
One memo for referring to Lokadalat Nilada. Matter has been set.
Take it and we'll refer it to local. Tomorrow is there.
Please.
Get it by 1:30. Yes. All the list, there are no much matters.
Yes. The announcement of order, CL number 1. Rupesh.
Here for the first respondent.
Dismiss.
CL number 2 for dismissal.
Dismiss.
CL number 2. Petitioner Shweta D. Rao, 14%.
Who is he going walking here and there? What is a reserve matter? Why it has come for dismissal?
My lord, what has happened in this case, my lord, is that there was an IA number 2 that was ordered on 3rd of April 2025. Before
No, 1 minute, 1 minute. She gave a wrong file. Yes. On 10/9/2025, this court has passed an order permitting the counsel for the petitioner to retire as a memo is filed. By producing the copy of the WhatsApp communication dated 29/8/2025 and 9/9/2025 sent to the petitioner, where the counsel has informed the party about the matter being listed before the court and for filing a retirement memo. As it, the said memo discloses that it is communicated to the party and party is aware of the pending proceedings in spite of pending proceedings. Then the matter, then this court is directed to print the name of the party and directed the matter to be listed today. There is no representation on behalf the party is not before the court, nor she has engaged the advocate in these circumstances. The matter is dismissed for non-prosecution.
Cell number 3 for orders matter, Pradeep B. Appellant, Vijay Kumar T.
Yes.
This case, my lord, claimants also preferred an appeal. Only quantum, my lord, R2 notice may be dispensed. Owner of the vehicle.
We'll have that number.
Please, ma'am.
No, anyhow, it is here. You can dispose it off. You can get that number. Yes. A memo is filed, second dispensation of notice. The second respondent who is owner of the vehicle. Accordingly, memo is taken on record and notice to the second respondent is dispensed with. Give that number. They will call for that file.
Number.
Call for that file. Yes.
Lord,
It is in
of
Kannada.
injury, it's a case of injury, my lord. I am challenging the future earnings awarded by the tribunal. On the ground that, my lord, the fracture of third and
No,
fourth.
his appeal is also there.
Yes,
Now we
ma'am.
will start from pain and suffering. How many are the injuries?
Fracture of third and fourth metacarpal.
Two.
Metacarpal.
2 fractures. So, how many? 60?
My lord, 10,000 has been awarded.
I'm saying 60? Or
40,000.
No, 40 for one. In addition, another 50,000. Yes. Then medical expenses as it is.
as it is mentioned. Loss of immunity is 10,000 awarded.
83,000 1 crore. Then how many days he was in hospital?
Please. Entire list is.
4 days in.
4 days, my lord.
Already enough. It should have been 4,000. We'll reduce it. Nourishment. Instead of that 5,000 and 5,000, 10,000, we are making it 4,000. Then what is the disability as per the doctor?
Not 7% whole body disability.
As per the doctor.
As per the doctor, that has been considered, my lord. My grievance is, my lord.
No, for 7%, what is this 5,000 as loss of 10,000 loss of immunities?
That's what, my lord. First, my lordship has to decide that loss of future earnings, whether he is entitled or not. Here, my lord, he is an income tax assessee. He has admitted in the course of cross-examination, he was produced the income tax returns 2018 and 19. The amount of
The
rupees
accident, when is accident?
18 and
Yes.
17/3/2019 is the accident. My lord.
Hmm.
My lord, 1,45,355 income tax returns we have filed. After that, my lord, 1920, 4,06,000
It increased.
increased, my lord.
Threefold.
That's what, my lord. Loss of future earnings does not arise, my lord. Loss of immunities, my lordship may grant more, my lordship.
Yes, Mr. Vijay Kumar. You have the file?
Please, my lord. My lord,
Internal
I
page
have
16.
produced the IT returns for the year 2018 and 19.
And also further,
But,
19 and 20 also is produced.
but I have not produced it, my lord.
Produced.
Yes.
It has forthcoming in internal page 16 of the judgment. Internal page 16.
We'll do one thing. In these circumstances, we cannot, we have to interfere with that. But still, you want to look into the file, list this
19.
matter as part heard, for judgment on Monday, along with that number.
Yes, ma'am.
Please.
That we'll hear you and pass orders on that.
Please.
Till number 4. Till number 3.
Yes.
Gita, please see.
Lordship, impugned order at Annexure K at page number.
What is this?
This
So
is
far,
on the
respondent is not served.
It is served. Served, and I have the acknowledgement also. Lordship
Cost
could
rated, cost list doesn't show.
No, actually, your Lordship, on the other day, there were two matters. Your Lordship has disposed the one matter where it is the application for modification of the interim order was challenged.
You this?
This is arising out of the execution where I just bring it to your Lordship notice. This is an
Let me just see how the notice is served.
acknowledgement I have.
File.
Yes. And in fact, on the last
Like
occasion,
this.
the advocate has come and submitted that he has given no objection, the connected matter, as she has taken the papers back. This is what the submission was made. Then your Lordship has
No. It doesn't appear so.
Connected number.
connected number.
As per the endorsement of dated 11/8/2025, furnishing of PF so and so. for
Lordship
the-
may just pass on this judgment. Your Lordship has passed the judgment on the. These two matter was connected, and your Lordship has delinked and has disposed of that petition, and wherein the respondent has submitted that he has already given a no objection.
No, that is in that matter.
Yes, in this matter also, yes. In this matter also, he was representing. I had served a copy also, and in fact,
What is this matter?
this matter is regarding the issuance of the arrest warrant against the
Oh,
petitioner.
it's a 2023 matter. Please take out hand summons on the council and file a memo to that effect.
Lordship may make one submission. There is a mediation agreement drawn. That is, I have produced the annexure, your Lordship, dated 24/6/2022, wherein what has happened, the respondent.
Please understand.
I do
No,
understand.
no, without that, if I pass an order, they come and file a review again, unnecessary The
I do
petitioner-
understand. I have taken, but still again, I will,
What you
I'll
have
do
taken,
the,
show that. When is
Your
it?
Lordship. On 24 to 20, 24/7/2024.
Take that.
Yes, please. This is the third time I had given, because in the open court when they had,
Very same advocate.
they're very same
No, he's
advocate.
appearing in the lower court
Same advocate.
as of now.
Yes, yes.
And he says he has given a
In
wakalat here.
fact, in the family court also now, he has said that he is not, because she has taken the papers back. So he is not representing, because on the day before yesterday, 3 days back, the matter was there. He has not appeared. Since he has not,
Party
the
is
order
coming.
party also not appearing, Your Lordship. That is the whole order sheet. Your Lordship could peruse. I can place it on record. The party is not turning up because she has entered into a mediation agreement. And the very same day when the matter was advanced, and she comes to the court and takes the DD, and the second round when the matter was to get settled and to fix their signature in the order sheet,
When
she
is
never
the
turned
matter
up.
going to list before the family court?
I just Your Lordship, right.
Then consider the petitioner submits that in the other connected matter, this court has disposed of by order dated 2923 of 2022. On the day the counsel appearing to the respondent has submitted that he has given up wakalat. It is submitted that in this case also, the counsel has served the copy on the counsel on 24/7/2024, and it is very much in the knowledge of the respondent. The respondent, even before the trial court also, is not appearing.
Lordship, it is on 211.
It's coming upon 211.
I just placed it on record.
You
Your
know,
Lordship.
you have an interim order?
I have an interim order.
Yes. The petitioner shall serve the hand summons on the respondent as well as the counsel, if any, representing. List this matter on in the month of October.
Lordship, the hand summons to be to the respondent.
Respondent, counsel, if any.
Yes, because respondent, I am not unaware of her whereabouts. That is the reason. The
Before
counsel,
the matter comes up before the court, family court, that day you can
she is not attending. That is the difficulty
let
for
the
me.
court record it.
Please.
Bring it to the notice of the court. Let it be
Yes.
recorded in the record.
We have
proceeding.
done that, Your Lordship. That is.
Till number 5.
You have a stay. Have it. We'll have it in the month of end of October. List on 30th of October.
Please.
Yes, next.
Lordship, no, 30th, I have some inconvenience. There is
October.
October, I have a,
4th of October, November.
please, great.
Till number 5.
Interim order earlier
Yeah,
granted is extended.
petitioner, my lords. In this matter, my lords, there is a
5.
objection, my lords, with regarding to memo filed by us, my lords, wherein the name of the
Yes, why are you not? That's what
My lord.
rightly they have raised the objection. No, every day I'm telling advocates, write the name. They will put their initial. How will the court know who is the counsel who has taken notice on behalf of the respondent? We'll direct the name to be printed. So please do it.
please, my lords, I will do it, my lords, and
Office
we have
objection.
taken steps also,
Office
my lords.
objections shall be complied with. Once the office objection is complied, is extended then. Yes.
Till number 6.
I'm up here for the appellant, my lords. I may be permitted to withdraw this appeal, my
Because they
lords.
had already
Please
filed
not-
appeal, my lord, it came to be dismissed in the year 2016. Now,
I'm not aware of on filing of this
I
appeal,
appear
my
for the
lords. I
second
provide
respondent.
Yesterday she was submitting.
Please, my lords.
Which
Yesterday I
which was
inquired.
which was dismissed in the year 2016.
16, my lords.
And again, your client will file an appeal now.
I'm not aware on that day file.
The memo is filed seeking to withdraw the petition. Then counsel appearing for the respondent submits
I'm
that.
for second respondent.
The submits that. The then counsel appearing for the insurance company submits that. The writ petition filed by the insurance company.
Well,
has-
MFA 4359 of 2014.
That is by whom?
Claimants.
Their appeal is also there.
Please,
That's
ma'am.
what she said.
Ours
appeal is also there.
Theirs is 7483 of 2013.
Ours means
I mean, this insurance company.
insurance company, yes.
Oriental.
Both the insurance company and the appellant have filed 2 appeals, and both the appeals were dismissed in the year 2016 itself. Considering the land counsel submits that it is not in a notice, the memo, the appeal is dismissed as a drawn memo is taken on record.
Till number
Yes,
7.
next.
In this case,
7, Raghu R.
R1 may be directed to take notice to the M.E. Maheshwarappa sir, my lord, and R2 my lord, A.
Your
Venkatesh, sir,
lordship,
my lord.
get the wakala. Copy received.
And
M.B. Maheshwarappa is directed to take notice in your case, which
For-
respondent he is.
for R1 my lord.
Mr. M.E. Maheshwarappa is directed to take notice on behalf of respondent number
1 my lord.
1.
R2 my lord, A. Venkatesh sir, my lord, they have filed the appeal my lord.
Is directed to take notice on behalf of the insurance company. R2 and the learned counsel shall serve the copy of the appeal memo.
Served the
on
served
the-
my lord.
Already served. Then IA number 1 of 24 is filed to condone the delay of 388 days in filing the appeal. For the reasons stated, delay is condoned on condition that will not be entitled for interest for the period. Yes, what about 50% of the award amount is this how deposited or not?
It is deposited, but I have not received the memo. I'll produce it.
I'll record it.
Yes.
Then counsel appearing with insurance company submits that they have already deposited 50% of the awarded amount, and by the next date of hearing, he will file the memo. Next,
Call for TCR.
Huh?
TCR required.
admit post of final hearing, call for the TCR.
Much of.
Till number 8.
Call for TCR, man.
ಆಗಿದೆ ಆಗಿದೆ.
Till number 8. Surya Kumar, MR for petitioner.
Notice to the respondent.
Till number 9.
Notice. You're already here. File your objections.
Yes,
I
we have
appear for
filed
the petitioner, my lord.
Yes. Let's see.
My lord, there is an IA pending for condonation of delay, my lord.
Yes, 529 days. What is the reason for the delay?
My lord, the
Please come
petitioner-
to your application.
Yes, yes,
IA.
my lord. Page 46. Lord, the petitioner was suffering with certain ailments, my lord. He's
What are
not.
the ailments?
Lord, he was suffering with diabetes and certain health ailments.
Diabetes, he can't come to the court for 2 years.
Lord, throughout that, throughout the trial of the 125 petition, I've always
No,
paid complied with the order.
was passed on 8/9/2023.
Yes, please, madam.
I have filed this petition to set aside the so-and-so. I have filed a divorce petition so-and-so. And the same was allowed on 4/10/2023. There is a delay of 529 days as I was suffering with diabetes and other ailments. As such, I am unable to meet my advocate and give instructions. What is this?
Yes, my lord. My lord,
Is it a reasonable cause to condone the delay of 529 days?
my lord, may I make one submission? He's a delivery boy. The petitioner at the respondent wife at the relevant point of time, she was earning more than the petitioner here.
No, let's forget about all that. I'm not going into the merits of the matter.
No, my lord, just to show my bona fides, my lord.
Just like that, whenever you feel like, you will not knock the door of the court.
My lord, one opportunity may be given.
No.
On merits of the matter, we will.
I am very strict on this. Without making a reasonable cause for the delay, just like that, will not entertain. You file a divorce petition. No, you file a divorce petition.
Divorce is granted, my lord. Divorce is
granted.
Yes.
Granted on 4/10. That you will pursue in spite of your diabetes. Yes, please come. The present RPFC is filed with a delay of 529 days. Agreed with the order passed in criminal miscellaneous number 100 of 2016 by the sixth additional principal judge, Family Court, Bangalore, where the court has granted interim maintenance of an amount or had granted maintenance of. Why are you saying interim maintenance? First of all, again, it's interim maintenance. How RPFC is maintainable?
No, no, my lord. Judgment is passed. I'm saying interim maintenance was awarded. I have not violated that order throughout the trial. That amount has been paid. They don't dispute it.
Initially, interim maintenance of 4,000 is granted, and later, court had passed an order. No, this order is dated 8/9/2023. Impugned order is 8/9. Monthly maintenance of 10,000 from the date of the petition, that is 15/2/2016. It is stated that he has also filed a divorce petition, and the divorce was granted by the family court, and that is MC number 3332 of 2016, dated 4/10/2023. Further, it is stated that he is suffering from diabetes and other ailments. As such, he could not contact the advocate. In the process, a delay of a delay of 529 days occurred. It is submitted that the delay is neither willful nor wanton. Unless a fair opportunity is granted to the petitioner, it would cause a lot of hardship to the petitioner. When counsel for the respondent has filed the objections, the respondent has filed the objections, and the land counsel appearing for the respondent submits that the delay, there are no reasonable grounds to condone the delay of 529 days. It is submitted that when the husband is prosecuting the divorce petition, there are no grounds and no document is placed before the court showing the incapacity of the advocate, the husband to contact the advocate. It is submitted that there are no grounds made out to condone the delay and the same may be dismissed. Having heard so and so, so and so. The petition is filed to condone the delay of 529 days. That is almost 2 years. When the petition is filed in condonation of the delay, rather an inordinate delay, the claimant has to make out a case. Why? He could not come before the court within the reasonable time. The reasons that are stated by the petitioner husband seeking condonation of the delay cannot be the grounds for this court to condone the delay. And the courts cannot permit the litigant to come to the court whenever he wants to come. The Section 5 application is to give an opportunity to the party by condoning the delay, provided reasonable grounds are made out. In the considered opinion of this court, there are no grounds to condone the delay. Accordingly, I number 1 of 25 to condone the delay of 529 days in filing the petition is dismissed. Or consequently, RPFC 139 of 2025 is dismissed.
Cell number Gautam Raghunath.
I appear for the petition in this case, madam. Yesterday I got the NOC.
But we'll be filing the memo of retirement in this matter.
Yes.
Also apologize that senior is not available.
Mr. Gautam Raghunath has filed his no objection, NOC Wakalat, and so counsel submits that.
Yes, ma'am.
He has instructions to file Wakalat. Yes, to file Wakalat. Mr. Gautam Raghunath is permitted to retire from the case. Yes.
Your Lordship, I will find the work in the office, Your Lordship. It should need it.
This is matter on Wednesday.
Cell number
We'll hear
11.
it on that day and I'll finally pass orders.
Cell number 11. Shankar. For petitioner,
My lordship, in this case, the only directions, my lordship, the
Let's see.
mandamus, my lordship.
Which court?
First additional family court, Bangalore, my lordship.
Which year?
2022, my lordship. Already covered by High Court judgment is there, my lordship.
That judgment will not follow because we have to follow certain things which are practically possible.
Yes, ma'am.
How can they dispose of thousands of cases with that timeline?
At least, my lordship, expeditiously dispose, my lordship, expeditiously.
Family court, first, the principal judge family court will dispose of matters till 2020 by December 15. Other family courts till 2019. Any matters after that, we will not pass any order, and there cannot be no out of turn because somebody comes to the High Court, we can't pass orders.
No.
That is standard instruction.
Yes, my lordship.
The no case is exception.
No, already, my lordship, what happened is that this honorable court has passed in directions, my lordship, given the directions, my lordship. Judgment is there.
That is the whole difficulty. Without looking at what is the pendency of the court.
Yes, my
So
myself.
it is ultimately, it's their board. Ultimately, they have to dispose it off. And High Court, just like that, in every matter dispose of, how can they do it? There
Only
should be some great reason that why a case is out of the turn to be disposed of.
my lordship, at
For
least.
every divorce matter is of same problem, same issues. So it can't be. There are 2016, 14, 15 matters are also pending before the family court. Why there is a urgency for a 2022 matter?
Because my lordship, the old age parents is there, depends upon.
Everybody will have old age parents. Everybody
Because
will have.
already age is out 31 years, my lordship. He is a 31 years old man.
I'll tell you, there are the parties
And,
who are at 75, and their petitions are pending. Your client is in a much better footing. Please come.
Because my lordship, at
It
least
can't be.
expeditiously.
Understand, I cannot pass such an order. I am also an administrative judge for the Bangalore family courts. I know what is happening there. So there can't be any order.
Kindly
Please
have it
come
next week, my lordship, at least.
next week. Please come.
At least, my lordship, this court pass an order, my lordship.
I will look into it. Please give that.
In serial number 3, my lordship, page number 3, my lordship.
The present petition is fine.
Court should make an
Yes.
all efforts, a court effort to try and dispose of the same within outer limit of 1 year,
Yes,
my
yes.
lordship.
The present petition is fine, seeking the following relief. Then counsel relying on the order passed by a coordinate bench of this court in N. Rajiv and Srimati C. Deepa, arising out of writ petition number 14769 of 2023 dated 26th July 2023, whereby the court has passed an order that when where a matrimonial case involves the prayer for the dissolution nullity of the marriage, court should make all efforts to try and dispose of the same within an outer limit of 1 year, so that in the event of granting, within inverted commas, so that in the event of granting such a decree, the parties may restructure their lives. It hardly needs to be stated. Life is lost in living. Delay in disposal of such cases very badly affects the parties thereto. Needs no deliberation. In the circumstances, the family court judge is requested to accomplish the trial and dispose of the subject 7 years old case, preferably within an outer limit of 3 months. Then counsel is relying on this judgment. According to him, the MC that is filed by the petitioner is
22/11/2022.
22/11. That is almost 20. It's filed in the year 23. It is not even 2 years old. This judgment will not come to his rescue on the first instance. Secondly, the family courts are burdened with work where the matters pertaining to 2016, 15 are also pending. This court, the Honorable Apex Court, the Honorable Apex Court in Catena of Judgments has held that the High Court in every matter, whenever in every petition, cannot issue directions to the family courts to dispose of the matters, as it is for the family courts to deal with the matters basing on the pendency of the cases before them, unless it is an exceptional case. This case is not an exceptional case where the matters of 7 years are pending this is just a case of 2 to 3 years old, and this court do not find any reasons to pass any order.
My lordship, sorry, my lordship, outer limit is outer limit. We are not asking the outer limit, my lord. At least expeditiously dispose the matter.
Why?
One word, my lordship.
Why?
Because already is a 31 years old male, my lordship, depends upon parent, only
Understood
old
what
age.
the court said.
That's because
You understood what the court
because
said.
no cohabitation between the parties. They are living separately, my lordship.
That's
No
what
purpose has been
happens in
served, my
every
lordship.
divorce petition. Why are you not understanding that?
Sorry, my lordship. At least expeditiously, my lordship. One word, my lordship. Expeditiously. That's not the outer limit of the.
Say, I will now, if you insist, I will say, don't take this 2023 case unless you dispose of, I already instructed them not to take any case after, which is, I mean, beyond 20, only against should be considered. When such directions are issued to the family court, contrary to that, can I pass an order in this? Yes, next.
Till number 12, Sudhin Robert for petitioner.
Yes.
This petition is only to modify the order dated 25/4/2025, my lord.
What is the order?
The order is visitation of the child Saturday, Sunday. No, my lord, I am not asking that. There is a video call is there every day. The child is not interested to connect with the.
What I want to say is, in all these matters, any of these visitation matters, unless the respondent is present, I will not pass any order.
Maybe notice.
That's why please take out notice on the
Much
council and file a memo to that effect. Once the memo is filed, list the matter.
Much.
Yes.
Till number 13. Till number 13.
Yes.
A. Ravishankar.
Yes.
Yes. Granting of a maintenance to the tune of 15,000 is under impugned the order.
What is the salary of the husband?
Husband, he is not, he is only doing helping to his mother in a sweet stall. That is been stated in the assets and liabilities.
That means they are earning something in the from the business.
No, he has done his LLB, but he is not practicing. That was.
That sweet business must be earning. There
No,
must be
it has
some-
not been stated in the assets and liabilities. Kindly have a look at annexure of page 66.
Anyhow, let's see, pay half of it.
Yes.
It is submitted that the court had granted 15,000, and the husband, without considering the income of the husband, it is submitted that though he has done his LLB, he is only helping his mother in running a sweet shop. The court, sweet shop, and he is not in a position to pay the amount, considering the submission, same 7,500, arrears at same 8 weeks, and hand summons, and a memo shall be filed by 14th of October, or else the stay granted by this court stands vacated even on that ground. Yes, next.
Highly obliged.
Somnath H for petitioner.
Yes.
I appear for the petition of Father, my lord. This petition is challenging the visitation order. My lord, the respondent wife has filed another petition challenging the maintenance order, my lord. The matters may be clubbed together.
List along with so and so on Tuesday.
No.
18th, my lord.
18th.
Notice may be issued, my lord. I'll serve a copy on the advocate representing the wife.
The petition is permitted to serve the notice on the counsel appearing for the respondent in the other writ petition.
Please.
Yes.
Cell number 15, HR Renuka
Grateful.
for admission.
Yes.
I'm representing on behalf of the appellant. This case, my lord, challenging the negligence.
Only negligence?
Negligence. 3 persons were proceeding on a motorcycle, my lord. They overtook the Tata Sumo and dashed against the KSRTC bus. Therefore, my lord, that is insured with United India, third respondent. They are the rider of the motorcycle as well as the driver of the KSRTC. Both were equally responsible for the alleged accident.
The charge sheet is filed against whom?
Against KSRTC only.
Then
But
what
my
is the
lord,
finding?
the manner of the accident, my lord, in the complaint, they themselves has given, the injured, who has stated that, my lord, 3 persons were proceeding on a motorcycle. The rider of Sachin, who was overtook the Tata Sumo.
For the injured.
Please, my lord.
Injured are?
Pillion rider. United India insurance is there, my lord. That's what.
No.
My lord, I represent third respondent insurance company.
No. What is the material to show? Like, is overtaking from the left side or the right side?
Right side.
My lord, 10-time negligence is attributed only to bus.
Afterwards, my lord, dash diagnosed KSRTC bus, my lord. KSRTC bus is coming opposite direction.
He is not overtaking the KSRTC bus.
No, my lord, Tata Sumo.
Let's see, let's read the.
Complaint, my lord.
No, no, let's read
Please, ma'am.
how they have stated about the manner of accident.
The deceased one, Siraj, was proceeding Tumbe Junction towards BC Road. At the side of pillion rider on a motorcycle, and the said motorcycle was ridden by his friend Sachin. In a slow manner and careful.
There is no other vehicle. As per
In the
their
complaint,
case,
in the complaint, my lord.
engineering was so and so, KSRTC bus being driven by his driver in a high speed dashing so and so.
May I read the
Driving dash
complaint?
to the motorcycle.
May I read the complaint, my lord?
Take out the TCR.
ನಿನ್ನೆ ದಿನ ತಾರೀಕು
Before going to complaint is bad.
the
That's why
cause
it is
of the
meeting also.
The admit, post of final hearing, call for the TCR.
Cell number
Yes.
16.
Appellant.
Raju, yes. B. Pradeep, sir, I have to.
In
Case
this
of
case,
death or injury.
injury case, my lord.
injury case.
Where is the table?
Records is necessary, my lord.
Why?
Brain injury, my lord. It's a 59% of the intellectual disability, my lord. Future earning, the loss of capacity is not awarded by the tribunal, my lord.
Required?
Yesterday, my lord expressed that he was continuing the Fairfax shop, my lord. He is doing the business. It has been admitted.
So in this case also we'll ask them to appear before to assess the disability.
No, my lord. What is happening is, after lapse of 2 years, the doctor has been examined. From initially, my lord, he has took the treatment. After lapse of 8 months, my lord, he has not taken any treatment. He has taken OPD only. Afterwards, my lord, in the cross-examination, he has admitted that he was doing the job. The grassy shop, my lord.
No, there is no dispute about the disability.
No, my lord, there is no loss of future earnings, my lord. He was running, my lord, a Fairfax shop. He has renewed the license also. And he is running the shop.
Person with 59%.
That's what, my lord, yesterday, my lordship expressed loss of immunities could be granted more like that.
Future earning.
Class examination may kindly be seen. If he is not working, my lord, what my lordship says is correct.
Even today is not working, my lord.
Let them file affidavit, my lord. He has not renewed the Fairfax
File an
shop.
affidavit, my lord.
Fairfax shop, he has not
Definitely, I
renewed.
file an affidavit, my lord. Intellectual brain injury, my lord. He's a poor people, a village people, my lord. He's illiterate. Illiterate.
1 minute. As far as whatever the evidence of the doctor and whatever is the disability, you are not disputing.
Disputed, my lord. After
Disputing
lapse
on-
of 2 years, my lord, there is no treatment records and there is no.
That's why
Please,
what we will say is, if really that whether he is having the disability or not, let him appear before the district, what is that board? Medical board.
Nimans.
Nimans board.
As medical board, you
Please.
appear and it is, then counts for the petitioner submits that. Is the petitioner, appellant submits that he is suffering with 59% disability. Intellectual disability. And counts
Brain
for-
injury.
because of the brain injury sustained in the accident. Land counsel for the respondent insurance company submits that no evidence in this regard is adduced. And even after the accident and the injury, is still working and that has no effect on his future earning. The appellant shall appear before the medical board, NIMHANS medical board on 8th of October. On 8th of October, and the NIMHANS shall communicate after the assessment, the same shall be sent, the certificate shall be sent to the registry. The registrar judicial is directed to communicate the same. Yes.
He himself has been examined. He has given answers, my lord, in the questions posed by the bracket. That's what, my lord. Otherwise, I would not have to.
So let's see from that.
Also, letter has to be furnished. To appellant also get the letter, my lord, from the registry.
No. Let's see that. Let's see from let them do independent assessment.
Cell number 17. Guru Prasad, BR.
Please, ma'am.
Yes.
Pradeep,
So
B.
yesterday's matter, my lord.
My lord,
They have
we
settled for 2
sent
lakhs.
all the files to the client, my lord. I request a week's time to clarify the same, my lord.
What is that?
But yesterday, my lord, sir.
Ah.
That,
Yesterday 2 lakhs they have
wife has
settled.
prepared on
No, it
petition.
is, you don't have the file.
My lord, after finish the matter, my lord, we sent the all.
You know, my lord, we
entire
have not
file, my lord.
deposited after intimating my learned friend. It could be disposed of, my lord, together that matter next week.
Please get instructions.
Yes,
And
please, ma'am. I'll
so
come.
next week, tell the court that that order will be reviewed and
Both
our
the-
common order has to be passed.
Please, my lord.
It is submitted by the learned counsel appearing for the insurance company submits that the court had granted compensation and that apportioned 50% as per the apportionment made by the tribunal, 50% of the compensation to the wife, 50% to the parents. Whereas parents have filed MFA number 7010 of 2022, and in the Lok Adalat, the insurance company has settled the entire claim by agreeing to pay 2 lakh over and above what has been awarded
To the parents only.
to the parents. The learned counsel submits that as it is 50% entitlement, the insurance company cannot settle for the entire claim and with the parents. And then this court has directed to print the name of the advocate who was appearing for the parents. Learned counsel submits that they do not have, as the file is returned, the entire papers are returned. As of now, they have no instructions. She'll get instructions. She shouldn't get instructions by next week. Then the court will hear both the matters and pass an order. We'll have it on 18th.
Please.
Obliged, my lordship.
Uh. Why to be accepted by the court? What is that? Wakalat of Ms. B. Pradeep is accepted. I don't know all weird procedures. Yes.
Cell number 18. Cell number 18.
Petition in this matter.
Sandeep Katti.
2 weeks time to file the retirement memo for retired in this matter. We have sent a letter to the notice to the petition in this matter. We are unable to contact the petition in this matter. Once they receive the acknowledgement, we will file the memo of retirement in this matter.
Do that. This is the RPFC of 2022. Till now, no orders, nothing has been passed in this.
Only thing is we are
Submitted on 23/7/2025 that parties have entered into a compromise and they will file a memo before this court.
after that the party is not contact with us. That's the reason we are filing the memo for retirement in this matter. 2 weeks time may be granted.
For filing memo of, it is submitted that the petitioner counsel wants to retire from the case and filing, as they have already sent the communication. Once they get the acknowledgement, they'll file the memo. Let's just matter after 3 weeks.
Bless.
Yes, next.
Number 19.
19 lords appear for the
Steering
petitioner.
group.
It's a matter lordship heard us not day before yesterday, but they were directed to find out whether she is willing for a settlement. They are supposed to tell today, my lord.
May be referred for mediation. I spoke to the party, my lords. She is ready to speak. She has some.
Lord, on 25th, my lord.
Here in Bangalore?
Yes,
or-
yes, here, my lord.
Here, my
It is submitted that there's a likelihood of settlement. Both the parties shall appear before the Bangalore Mediation Center on 25th.
My lord, here itself, my lord.
mediation.
High Court
right.
Mediation Center.
Yes, ma'am.
Before the High Court Mediation Center on 25th.
Much.
Grateful, my
Cell
lords.
number 20. Cell number 20.
For the petitioner.
No notice till now.
My lords,
Sir.
Shaker
L.
L is the advocate. No representation on either side.
Lord of the
This what is the matter about?
trial court, not the husband, not the approach the family court. After knowing her, not the antecedents and not the she concealed not earlier her first marriage and not the children.
What is impugned order?
Well, impugned order is annexure A, my lord. Annexure A, my lord, the page.
Is entitled
Pay-
for
pay-
interim maintenance of rupees 6,000.
6,000 ಮಾಡಿದ್ದಾರೆ from the June 2022 to till this month and December 2000 the petitioner is entitled to monthly maintenance of rupees 10,000 thereafter. The fact is this she concealed her first marriage and immediately after the marriage
MC is for what? MC is for
MC is
divorce.
for seeking divorce on the ground
Filed by
of
husband. On the ground of?
on the ground of cruelty and cruelty.
Hmm.
After the marriage, she tried to blackmail him, and she did earlier also. It seems, she come to the knowledge of the same. What happened earlier? It is a love marriage, and parents were not attended the marriage, and these persons were in rented house. She wanted to live with his parents. She innocently took her to the parents' house. Wherein he after knowing their properties and all, she started blackmailing this person. And immediately coming to know about these things, he went and filed the divorce petition. And she also filed the objection, stating that he was aware of.
So, as far as this IA is concerned,
Yes,
this petition is concerned,
Yes.
we are not concerned with all those issues which will be decided by the court. Now, we are only concerned with how the maintenance that is granted by the court cannot be, is not right.
Now, he actually, he earlier he was working. That project was completed. Thereafter, COVID-19 started. He doesn't have any work.
Have you filed your statement of assets and liabilities?
No, in this matter.
Both of you both the parties shall file their statement of assets and liabilities before this court. Basing on that, the orders will be passed by this court, listed in the month of October.
Cell number 21.
No representation on behalf of the respondent. Yes, 21.
I
My
appeal
lordship,
for
we are
the
seeking-
petition in this case, my lords.
We are seeking
As
time to
regards
file
the
objections, my lord.
Rejection of interim maintenance to the minor children, my lords.
Yes, come up with the objections.
Next,
My
my
lordship,
lords.
meanwhile, if the other party is ready, there's possibility of settlement may be referred to mediation.
Anyhow, we are posting this matter in the month of October.
Next week, my
In the
lords.
meantime, 1 minute, in the meantime, go for mediation. It doesn't work out, fine.
High Court itself, my lords.
High Court mediation.
When counsel the respondent seeks the time for filing objections, it is submitted that there is a likelihood of settlement. Party shall appear before the High Court mediation on 18th. 18th?
Please, my lord.
Obliged.
Cell
Yes.
number 22. BN Mahesh Chandra. For appellant petitioner. Rangaramu V.
Appear for the respondent in this case.
Yes.
Its impugned order is at page number 54, my lords.
50?
54, my lords. The reasoning starts from page number 63, my lords.
Hmm.
In the last date of hearing, my lords, your lordship has directed me to take instructions as to what is the crop that has been grown by the petitioner. And it has been informed, my lords, it is ginger and it is not in a good condition. It is already disease resistant. Your lordship had also directed me to take instruction what is the amount that he is earning per month. He is earning about 8 to 10,000, my lords, approximately.
It is wife and child or only wife?
Wife, my lords. The marriage only subsisted for a week, my lords, maximum for a week. And as per them also, it is only 20-25 days. As per us, it was only a week. She was residing with us in the matrimonial house. Thereafter, she got shifted to her native, that is Mysore city. And the petitioner is from a village in the vicinity of the Mysore city. Thereafter, there was a rift and they could not continue the marriage. And she files a complaint after 3 months in the month of April. Subsequently, a petition has been filed seeking the maintenance. The trial court was pleased to award a maintenance of 10,000 per month. Your lordship has awarded a 5,000 and rates, my lords, he has deposited. I sought instructions.
May I submit, my lord? The last occasion, because petitioner is having a total income from dairy about 40,000 per year, and he has one house, 2 sides are there, 1 acre of land, vegetables and ginger.
No,
is-
please tell the court what is. What is the income derived from that? Having properties itself is not
I am
sufficient.
telling, I am giving the
So
details.
please tell that.
Madam,
So
madam.
40,000 per annum is from the agriculture.
From the agriculture and also he is owning, put him,
Two cows are,
two cows are, dairy is running dairy and also he was the president of the Milk Area Association.
Dairy income, 40,000 rupees per annum.
Per annum.
Hmm.
And
Own
also-
house,
and
site
also-
1 acre land.
He's
Dairy
growing
president at president in Tibba and Hundi. Rent house advance, gold pledge.
My subject matter. The kind permission, they insisted to transfer to Mysore from the village. And the mother, by pledging the jewels and she obtained the rent agreement.
That is the wrong
residing-
submission. Manoj.
And he is paying 5,500 rupees per month rented house and 55,000 rupees advance paid by the mother. And he is telling that I will get the house from the so the petition is telling that. It's totally false. I've got a copy of the rent agreement between the parties and between the wife and the owner of the property. So she has no means at all. She unnecessarily deserted the respondent hearing, wife, without any reason. And the maximum is the example court was granted 5,500 for rent and other livelihood also. It's quite difficult to maintain herself. She is not working. She is not studied.
No, it is like this. You have to place something on record to show what is the income. Basing on these kind of communication, court cannot pass any order. If you have anything to say that this is the income of the husband, basing on that, we can grant maintenance. Or else, because it's a burden lies on the wife initially to show what is, how she is entitled and what is that he is having.
My humble request, whatever the order made by the state court, they say may be confirmed. Because till then, let them instate before the trial court and produce.
When from when they are residing separately?
That's from there,
After 1.5 months, my lord.
Year I am asking.
2024.
2024.
15/7/12/2023 is the date of marriage, my lords.
Hmm.
As per their assets and liabilities itself, from 15/1/2024, they are residing separately.
7/12
Any matrimonial proceedings are initiated?
Yes, my lords.
By whom?
I think, my lords, by the petitioner itself.
By the husband.
Yes, my lords, by the husband.
Then, yes, is the wife interested to stay with the husband? But he is not interested.
Lords,
But she has filed the case.
I may make only one submission,
16
my
or
lords.
24.
They,
Petition
in
is
their
petition.
own petition, they say that they accepted to get married to the petitioner only on the ground that the petitioner said he will make a house in the Mysore city itself and they will reside. Now they are coming and making a statement that the petitioner wanted a house in Mysore city. That's why they made the petitioner's respondent's mother.
For this ground, no, both of them are staying separately.
Yes, my lords. My lords, I am having agricultural land. I am having 2 cows. If I come and stay in Mysore city, my lords, how the household will work, my
First,
lords?
for the mediation done at any point of time,
I don't, my lords. I don't have
that
instructions.
both the parties appear before the mediation center in
I mean,
Bangalore.
Mysore, my lords.
Mysore.
Mysore.
Both the parties are directed to appear before the mediation center in Mysore on 22nd of September.
Interim order may kindly be.
The order earlier granted is extended till then. List this matter in the month of October, once the mediation report is received.
Kindly, grateful, my lord.
Till number 23,
22nd, ma'am.
22nd night, 22. Shankar Avinash.
I'm applying for petitioner. My lord, in page number.
For respondent, ma'am.
Yes.
Ma'am, MC case was, marriage was.
Come to the impugned order, page number.
Okay. Page number 30, my lord, where it was ordered by trial court 15,000 rupees maintenance.
Court had granted 15,000.
Yes, my lord. And plus-
15,000 and 5,000.
Litigation charges, my lord.
What is your income?
My lord, I have a small BD factory, which is in Tumkur Gubi.
How
And,
much you're earning?
ma'am,
As per the statement of assets and liabilities.
like 3,27,000, my lord.
Per month.
Annually, ma'am.
3,27,000.
Yeah.
Mm.
And I have I have made 2 houses, my lord. In one house, already a respondent staying in that premises. And I am staying in my parental house, taking care of the child son and daughter, my lord.
Or with you?
All are with me, my lord.
Hmm.
And I also
Hmm.
given a property registered in respondent name, my lord.
Which property?
And it's a G, my lord.
The property which she is living now.
My lord? No, that is one more house. When she tortures me that I need a separate house, that time I make another house and make a stay, my lord. So after that, during the pendency of MC case, ma'am.
So now the son and the daughter are staying with you.
Yes, ma'am.
How old are they?
Ma'am, they are major, ma'am. One is 27 years old, studying in Australia, ma'am. And one is doing engineering in Bangalore, ma'am.
Who is taking care of their expenses?
Petitioner only, my lord.
What do you say?
My lord, the petitioner is running a BD Gadang, my lord. It's a big company in Tumkur district. It has got very good income with the BD company. Point number one, my lord. Point number two.
Before that, has he filed a statement of assets and liabilities?
Yes, my lord. Both
What has he
as
mentioned?
far as my client instruction, both been filed. Mine income is zero. I've been shown because.
To understand what is the query of the court. He has filed a statement of assets and liabilities.
Yes, ma'am.
He has filed his bank statements.
Yes,
He has filed his income tax returns.
Yes, ma'am.
When it is filed, we cannot assume something else.
No, my lord. Based on that only, I'm
Based
submitting,
on
my lord.
that, he is saying that income is 3,27,000.
More than that, it is there, my lord. Actually, that is in the
Where
as
is
per
the
my,
statement of assets
because
and
they have not disclosed it. Yesterday only they've been submitted a copy. As far as my
Disclosed
client
before
instruction.
is before the
Yes,
trial court.
yes, my lord. For the reason, no, my lord. My submission in this manner for the reason that I said. Yesterday they have been given.
Get
for
it,
the
we'll
reason.
have it on Monday. We'll hear it on Monday.
Ma'am, on 23rd, there is they have already warrant issued in trial court. On 23rd is the case.
It will come on Monday. Monday is before
15th.
that. By that day you file all that. This is a matter on Monday.
Please, madam.
Finally, event cell number 24. Ashok and party.
No pass outs today.
I am Fraxi Council, my lord, on record council request.
No, I understand that, but no
Please,
pass outs today.
please.
We'll have it on 18th or 19th.
Please, my lord.
99. Cell number 25. Kim Ananda.
Climate appeals.
I appear for respondent number 4 in MFA 1707/22, my lords. By another connected, my lord, MFA 2258, first case, bar 21. I have not furnished the copies.
What copies? Same judgment. Yes.
And another insurance company is there, my lord.
Which is an
Cholamandalam. Pradeep may be directed to.
Pradeep, 25. Mr. Pradeep is directed to take
He may be
notice.
directed to take notice.
On behalf of the insurance company, counsel shall serve the copy of
Copies already
the,
served.
you also served on him. Serve on him. These two matters on 19th. 19th.
19th.
Yes,
Cell
next.
number 26. Cell number 26. Kavita SC.
Claimant appellate.
PP
It's a
Rana.
case for enhancement, injury case, my lord. It's a fracture of tibia and fibula, my lord, head of fibula. There is permanent disability of 28.6%.
Let's see the award.
My lord, it's in Kannada, but I have given the copy to the other side and she's ready. My lord, the award is at
No,
page.
if I have to go into any other issues, I cannot.
It's only enhancement, my lord. Plain and simple.
Even pain and suffering, everything is written in
Kannada. Yes.
what is, how much is awarded for pain and suffering?
My lord, 45,000. My lord.
What are the injuries?
Injuries are fracture of head of fibula of right leg, my lord. Fibula of right leg. Then comminuted fracture, that is a compound fracture of distal tibia of right leg. Then lateral malleolus right leg. Then there's a laceration over forehead, my lord. 3 fractures.
What do you say? 60,000.
Hello, yes.
Yes.
And
Then how many days he was in hospital?
12 days, my lord.
How much the court had granted?
25,000. No, that's very less, my lord.
It is very less.
Yes.
If their appeal is there, it would have been reduced. 25,000.
25,000 is given already, my lord, but my lord, I
But
am
I'm
seeking
saying
it.
if their appeal is there, we would have made it. Now anyhow, their appeal is not there, we are not reducing it. Yes, next.
My lord, and laid up period, my lord, 18,000 is awarded for only 2 months, my lord.
Which year is this?
This is in 2018, 4 months at least, my lord, he's a coolie.
Which?
That he wouldn't have been able to earn because it's a
Drawback is
leg
instead of
fracture.
12,500, they have taken 9,000.
Huh?
Instead of taken income, as per the chart, 12,500, they have taken 9,000.
12,500.
That is the only latches. That is the only drawback in the.
12,500 into 4. 4 comes to 50,000. Then?
Under the head of permanent disability, my lord.
No, one more. What, according to the doctor, what is the disability?
Disability is 28.6%, my lord.
20 point?
28.6%. For the
Court had taken?
My lord, 2018 is the.
Court had taken 28.6.
No, 9.
9% is taken, my lord, but functional disability I'm seeking.
No, 28.6 is a disability to the limb.
Limb, yes.
For whole body, they have taken 9.
Functional disability, my lord, I'm seeking, my lord, because he's a coolie, manual laborer, and it's the lower body fracture, my lord. He'll have to
Court
stand.
had taken 9%.
Court had
We'll
taken
take 10%.
9 is absolutely correct, my lord, because the
9.53333. So it will come to, we'll take it 10.
And my lord, income, my lord, is
Income will take
12,500, my lord. And amenities, my lord, doctor is
Let us
examined.
calculate this for.
Yes, yes.
What is the multiplier?
11, my lord, 55 years.
It's coming to 1,65,000.
Yes.
Then amenities, how much is given?
My lord, amenities is 30,000, but doctor is examined. He has stated the malunion of the tibia of right leg, my lord, and it is bent to the right side.
Disability of 10%. How much it is required? More than 10,000?
My lord,
30,000.
my lord, I would submit, my lord. He is a coolie and is unable to squat or even walk freely without, there is stiffness in the limb as per the doctor.
Will not
There is
increase.
evidence on record, my lord.
Any future operation?
Future operation, because there are implants, my lord. There will be removal of the implants. Nothing is awarded under that head.
Yes,
Because
then
they have
that,
not
under
produced
that head
any
will,
estimation.
which year is this?
2018.
Will about 20,000. So done, all the heads are done.
Yes.
Income is taken?
My lord, 9,000
9,000.
notional is taken, 12,500 as per the chart.
Is coming to 3,60,000 against 2,25,834. Please come.
Interest may be 6% may be awarded.
Enhanced amount 6% because your appeal is not.
Act has imposed, that court below has imposed 9%.
No, for the enhanced amount 6%. Agreed with about passed in. What is this MBC number? MBC number
This is 786 of 18.
2018 dated 30th December 2019. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking a compensation of an amount of rupees 10 lakhs for the injuries sustained by the claimant in the accident. The tribunal has awarded the compensation as per the table given below. What you do is the table write in English, not in Kannada. 21. has granted the compensation as per the table given below. When counsel appearing for the appellant claimant submits that the court ought to have taken the income as this accident is of the year 2018, 12,500 ought to have been taken the income. It is submitted that when he has sustained 3 injuries under the head of pain and suffering, the court had not granted a reasonable compensation. Coming to the loss of income during the later period, court had granted only 2 months. Had granted only 2 months. It is submitted that when the doctor's evidence is that he has doctor's evidence is he has sustained 28.6% disability to the limb, and court had taken 9%. Considering the functional disability, court ought to have taken or ought not to have taken such a less percentage. Then as there are implants, it requires future operation. No amount is granted. Coming to the loss of immunities also, the amount that is granted is not a reasonable amount. Next, land counsel appearing for the respondent, you are for the RTC.
State case RTC.
Then counsel appearing for the case RTC submits that the tribunal on all counts had already granted a reasonable compensation and no enhancement is called for and no interference is called for with the well-considered order passed by the tribunal. Next, having heard the counsel's on either side, peruse the material non-record. The claimant had sustained 3 fractures. Considering the same, this court is granting 60,000 at the head of pain and suffering. The court has already granted enough amount for attendant for the incidental expenses and loss of amenities. This court do not find any reasons to interfere. Coming to the loss of earning during the later period, considering the 3 fractures and also this accident has happened in the year 2018 under the taking the income at 12,500, this court is granting for 4 months comes to 50,000. Loss of future income, the 28.6% is a disability to the limb and to the whole body. This court is inclined to take 10%. 12,500 into 12 into 11 into 10 by 100 is 1,65,000. There is no dispute about the facts that there are implants. For the future operation, this court is granting 20,000. In the light of the law made so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 3,60,000. The appeal of the claimant is partly allowed, enhancing the compensation from 2,25,834 to 3,60,000. The enhanced amount shall carry 6% interest.
Till number 27.
Obliged.
Purti Hegde of appellant.
For the
Ravish
appellant,
Binni.
claimant appeal for enhancement, my lord.
Where is he? Some other day? Same, 19th.
90.
Please, ma'am.
Till number 28. Till number 28.
Lord, the claimant's appeal, my lord, on
Passages.
2 grounds, my lord, on the enhancement and on the question of liability, my lord.
Liability is fixed on?
Only on the ground that, my lord, there was 2 pillion riders in a motorcycle, my lord. Entire liability was fixed on the owner of the motorcycle, my lord.
Who are the injured?
Pillion rider, my lord.
Rider and pillion all are injured.
Claim is by, my
Hey,
lord, the
dash.
pillion rider.
No, the claimant is a pillion rider.
Yes, ma'am.
No, the vehicle is not having insurance.
It had insurance, my lord.
Then why?
My lord, the MACT holds 3 persons were riding the.
Come to that finding.
This. That is the only finding, my lord. My lord gets it at para 24, page 17, my lord. My lord, in fact, learned member, my lord.
The owner of the vehicle, I mean, the rider of the vehicle is the owner of the vehicle.
Yes, ma'am. Para 24, my lord. Though, my lord, MACT extract the judgments of the honorable courts, my lord, wherein liability was fixed upon the insurance company. Nevertheless, in para 24, my lord, without discussing that, my lord, doubts. It is true that as per section 128 of the Motor Vehicles Act 1988 imposes a restriction on the driver of 2-wheeler motorcycle not to carry more than 1 person on the motorcycle. Section 194C inserted by the Amendment Act 32 of 2019 prescribes a penalty for violation of safety measures for motorcycle drivers and pillion riders. Therefore, the fact that a person was pillion rider on the motorcycle along with the driver and 1 more person on the pillion may be violation of law, but such violation by itself without anything more. It is also true that the police records are admissible in evidence and tribunal can rely on the said record to ascertain whether accident is occurred or not. The charge sheet produced by the petition.
So, filing the charge sheet on the rider of the vehicle for violation of the rules.
My lord, 3 persons cannot
Travel.
in a motorcycle. But there is a decision of this court, this is the decision of the Madras High Court, my lord. Very clear.
But there is a judgment of the Supreme Court.
Well,
No,
contribute-
whether because 3 people are riding on the motorcycle,
Yes, my
because
lord.
of the triple riding,
Allah,
that is a reason for the accident. It's the
Yes, ma'am.
first thing.
Yes, ma'am.
Number 2, he's a pillion rider.
Yes, my lord.
So if you are talking about the owner of the vehicle filing a case against, then it's a different case.
Yes.
Pillion rider, that issue will not come.
Yes, my lord.
So
But what this judgment says, my lord, there are 3 persons who are traveling in a motorcycle either without noticing the bus. Allah, this is a case of different aspects. But they themselves as attributed to the accident.
no, that's what. Where is that evidence that they have contributed? Even if it is contributed, it might be the rider of the vehicle, but not the pillion rider. When there is a insurance,
Well,
pay
one
and
more
recover
judgment
is-
is there, my lord. I have not brought that judgment. They should, for
Lord,
pillion
the
rider also
Honorable
15%.
Supreme Court has, my lord, has a clear.
15% contribute negligence is also there, my lord. He knows very well about the judgment.
No, if it is there on the pillion riders.
Yes, my lord. On the pillion rider also. 10%, 15%.
Happen is-
Alala. In this case, my lord.
Triple riding is not permitted.
Yes, my lord.
Triple riding is not permitted. That is an offense as for the traffic, this thing or other
The motor vehicle.
motor
yes.
vehicles, this thing.
Yes.
But as far as the compensation is concerned, why should the insurance company be absolved from the liability? No, because here the owner is driving
Yes, yes.
and he is carrying 2 other persons, and it is violation as per the violation of
128 of the Motor Vehicle Act.
maximum. It would be pay and recover.
Yes, my lord.
Yes.
Yes, my lord. So for the judgment of the Supreme Court, my lord, has clearly laid where 3 persons were there, my lord. The Honorable High Court has imposed some contributory negligence on the
Contributory
rider.
negligence, my
Then
lord.
the Supreme Court said, my lord, at best, my lord, it will be an offense under the Motor Vehicles Act. Question of, my lord, attributing negligence and
But
exonerating insurance
here,
company.
because the owner is riding the vehicle,
Yes, my lord.
will impose pay and recover in this.
Yes.
What about the notice to the respondent, owner of the vehicle?
Served and, my lord, and
Third, unrepresented, my lord.
And then what about the compensation now?
compensation is concerned, my lord.
Come to the table.
Compensation rightly handed a
We will
compensation.
see. We will
Yes, my
see.
lord.
Yes. How many are the injuries?
My lord, 4 injuries, my lord. There are fracture of ulna and radius. Then, my lord, fracture of tibia and fibula, my lord. Table, my lord, gets it at page, my
What
lord,
do you
15.
say? 4 fractures.
Yes, my lord. 60,000 has been awarded.
40, 50, 60. So we'll grant 70,000.
Another 20,000, my lord.
Another 20,000.
Yes.
80,000.
Yes.
8 days inpatient, my lord, in the hospital.
4,200 has been awarded.
We'll grant another 4,000.
Another 4, my lord.
Then, my lord, income was assessed.
1 minute.
Medical expenses as he has produced.
8,000. Medical expenses as it is.
As
Yes,
usual. Regarding loss of future income, he says that
1 minute.
he is earning about, as per the chart, 11,000 is earning.
Loss of income during laid up period. Which year is the accident?
My lord, 2017, my lord. 11,000 is
17.
the income, my lord.
11,000 as per the chart.
Yes, my lord.
Court had taken.
9,000, my lord.
So 11,000 into 4.
3 months, my lord.
So
In
many
1 month.
injuries.
My lord is making pay and recovery. Therefore, my lord, 4 months could be given, my lord.
Alala. 3 months is sufficient, I think, my lord, according to the evidence.
No, with this many we are granting. Then
Yes, my lord. Amenities,
loss
20,000
of
has been awarded,
amenities.
my
What
lord.
is the evidence of the doctor?
Doctor says, my lord, there is a disability of, my lord, 9% to the upper limb. Then, my lord, disability of 18% to the lower limb, my lord. Is the evidence.
Court has rightly taken a 10.5%, my lord.
10.5% was taken by the MACT.
Rightly taken, my lord.
So it comes to around 29.
Yes, ma'am.
Court had taken 10.
10.5%.
That is,
10.5.
Yes.
yes,
It's already on the higher side. Will not interfere with that.
Yes.
Loss of amenity. Loss of amenities, how much is granted?
20 was awarded.
50,000. Another 10,000, my lord.
I thought I'll not grant.
Loss of future income could be recalculated, my lord, by taking 11,000 per month, my lord, instead of 9,000.
11,000 into 12 into
18 and
what is
10.5.
18? You
Multiplier
multiply.
is 18, my lord.
into 10.5.
Age report. Age of 20 years, my lord. Age report. Yes, my lord.
Any future operation?
60,000 was the evidence required. Is the
What was
evidence.
granted?
My lord,
20,000.
MACT holds, my lord, 20,000 that will award, but not added in
Para
the.
20.
It was not awarded, my lord, ultimately. In the discussion, MACT holds 20,000 will be awarded.
20,000 maybe, my.
Will grant the same amount, 2,49,488. Then future medical expenses,
Another 20.
20,000.
Could be on the.
Another 20,000, my lord.
Could be on the, my lord, radius and ulna fracture and tibia and fibula fracture. My lord,
40,000. He's very generous. Comes to 5,92,964 against 4,08,644. Please come. Agreed with the award passed in MEC 1411 of 2017 dated 18th December 2020, whereby the court had fixed the liability on the owner of the vehicle and also seeking enhancement of the compensation. The claimant is before this court. Land counsel for the petitioner's appellant claimant submits that as the claimant submits that the claimant is a pillion rider as three people were traveling or were on the motorcycle. The tribunal had fixed the liability against the owner of the vehicle alone. It is submitted that in the light of the settled law, if there is triple riding, it would be an offence as per the provisions of the Motor Vehicles Act, but it cannot be a ground to fix the liability on the owner of the vehicle. It is submitted that the court ought to have fixed the liability on the insurance company, but not on the owner of the vehicle. Then coming to the compensation, it is submitted that when he has sustained 3 fractures under the head of pain and suffering, the amount and that is awarded is not reasonable. He was in hospital for 8 days. Even under the attendant charges also, court has not granted a reasonable amount. Further, the court had taken the income at 9,000 as the accident had taken place in the year 17.
Please.
It ought to have been taken the income as per the chart at 11,000. It is submitted that and all other heads, the amount that is awarded by the tribunal is not just and reasonable. Though the tribunal had the doctor's evidence is he requires 60,000 towards for the future operation. The court in the judgment discussed about 20,000 to be granted, but when it comes to the calculation, the same is missing. It is submitted that on all the counts, the amount of compensation needs to be enhanced. Land counsel appearing for the insurance company submits that the 3 people are not supposed to ride on the bicycle. It is submitted that the owner who is having well known about this fact is carrying 2 other persons along with him. That itself amounts to violation of the terms and conditions of the policy, and it's an offence as per the MV Act. In those circumstances, the court had rightly fixed the liability on the owner of the vehicle. It is submitted that even on the other counts also, the amount that is awarded by the tribunal is just and reasonable. Though owner of the vehicle is served, is
In trial court also it has been served, my lord.
both before the ex parte.
Yes, my lord.
Both before the trial court and this court, though notice is served, he has not appeared before the court. Next part. Having heard the counsels on either side, there is the material on record. First, coming to the liability aspect, the claimant is a pillion rider. If the owner has committed in violation of the terms and conditions of the policy, or he has violated any of the terms of the Motor Vehicles Act, that cannot be the reason for the court to fix a liability on the owner alone. The pillion rider is a third party to the insurance policy. The owner of the vehicle, in spite of the notice being in spite of the notice received, he has neither appeared before the trial court nor before this court. In these circumstances, this court holds that the insurance company is liable to pay the compensation, and the same has to be recovered from the owner of the vehicle. Then coming to the compensation, considering the three fractures sustained under the head of pain and suffering, this court is granting 80,000 towards attendant food and nourishment as he was in hospital for 8 days, 8,000. Medical expenses, 1,31,484 as it is. Then loss of income during the laid-up period, considering the injuries and taking the income at 11,000 as per the chart into 444,000. Loss of amenities, the court had granted 20,000 and this court is granting another 30,000. Then loss of future income, 11,000 into 12 into 18 into 10.5 by 100 is 2,49,488. Future medical expenses, considering the three fractures, this court is granting 40,000. In the light of the law laid down so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 5,92,964. Accordingly, the appeal is partly allowed, enhancing the compensation from 4,08,644 to 5,92,964, and the enhanced amount shall carry 6% interest, and the insurance company shall pay the amount and record the same from the owner of the vehicle.
Cell number 29,
Yes.
Srinivas MY,
Claimant appeal, my lord.
appellant,
Waiting for second respondent.
Pay and recovery, note there
That's the only thing.
only.
Yes, but
Please, no DL, 3-1 charge sheet. The liability fixed against the owner of the vehicle before the tribunal.
that's what pay and recover will order. That novel argument we are not going to consider.
That's what I'm not expressing.
The claimant is before this court, agreed with the award passed in embassy number 1192 of 2016 dated 24th August 2018, where the tribunal had fixed a liability on the owner of the vehicle. The land counsel for the
lordships kindly, my lord, I'll take leave, my lord. My colleague will be here.
yes.
The lordship.
Then counsel appearing for the the appellant submits that even if there is violation of the terms and conditions of the policy, and even if the driver of the offending vehicle is not having a valid driving license, the appellant being a third party to the insurance, in the light of the law laid down in Swaran Singh's case, insurance company is not liable, still the insurance company. Now, the principle of pay and recover will apply, and the insurance company shall pay the amount and record the same from the owner of the vehicle. But unfortunately, in this case, the tribunal had fixed a liability against the owner alone. As such, there may be an order of pay and recover. Land counsel appearing to the respondent insurance company submits that the court had rightly fixed the liability on the owner of the vehicle, as it is a case where there is no driving license. It is a fundamental breach of the terms and conditions of the policy. As such, the principle of pay and recover will not apply, and the insurance company is not liable to pay the compensation. Next, having other counsels on either side for the material on record. In the light of the law laid down in Swaran Singh's case, the appellant being the third party to the insurance policy, and the principle of pay and recover will apply. Accordingly, the appeal of the claimant is allowed, holding that the insurance company shall pay the amount and record the same from the owner of the vehicle. Yes, next.
Cell number 30, P. Mahadev Swami for appellant, Mohan Kumar T.
Who appears for the appellant?
Mahadev Swami.
Let's see. Let's see. No, where is the Order sheet. One minute. Legal representation on behalf of the appellant, dismiss matter for dismissal, give some date. Counsel for the respondent is present. Give the date.
24/9. Chair number 31.
I appear for appellant in this case. Madam.
Mary Janardhan Reddy.
Janardhan Reddy.
Madam, they have to serve us copy. Any date may be given.
Huh?
They have to serve us a copy in 31.1, my lord. Kindly, any date may be given, my lord. I'll
Mr.
seek.
Janardhan Reddy is directed to why or what these copies will do.
And next week, any date may be given, my lord. We're ready, my lord. Just ask
You
why.
are ready today?
No, my lord. We don't have the copy. I'll just look into the copy. Maybe 2 days' time may be given, my lord. Please,
Give
ma'am.
the 24th. Janardhan Reddy is directed to serve the appeal memo in 31.1 on
Any short date?
Sushmita Ji. 31.1, Sushmita Ji is directed to take notice and Ravindra P. Yes, next.
Chair number 32.
Any date may be given, my lord, please.
Yes, yes.
Well, in this case, my lord,
24/9.
Much obliged.
some,
Comes up.
32.
yes, my
It
lord.
is submitted that the insurance company is ready to pay an amount or with global compensation of 30,000 and they'll file a joint memo at 1 o'clock.
Please.
Yes.
Chair number 33.
I am for appellant in.
My lord, I am for the appellant in the first matter, my lord. This is an ex parte judgment, my lord. Kindly, this appeal may be remanded back to the tribunal for with fixing a date so that it's an ex parte against the insurance company.
Why
We
you
are
have
not-
not appeared before the court? What is the reason?
My lord, no notice was served, my lord. I don't know how. In many number of cases in Mysore, my lord, even we have given complaint to the registrar also about that court, and court has given direction. Wherever, my lord, the insurance companies are appeared and if they are placed ex parte, call the panel advocate and go on with the matter.
For disposal of the matter. So on what ground now it has to be set aside?
My
No,
lord,
that
it
is
an
ex parte order
judgment.
is one aspect. You can even look at the order and what is wrong with that you can submit.
My lord, actually, my lord, what has happened, my lord?
That's what.
There is no
What you can do is, Mr. Vijay Kumar, look
please,
at the
madam.
order and tell the court what is wrong with the order.
My lord, regarding the.
There is nothing wrong.
Wait, 1
That's
minute.
for him. For you, it is no wrong.
My lord, the alleged accident has taken place on 13/11/21 and complaint was given on 17/1/2021. After 4 days, our vehicle is not at all involved in the accident. Even the owner of the vehicle also contested the matter and he also denied the very accident itself. Very involvement of the vehicle itself is in dispute. Not only on my part, even the owner also filed the written statement. He has denied the very
So
involvement.
this is not going to go anywhere. He will be submitting the same argument. Give it. Let's
No, my
remand
lord,
the
kindly see the remand, please remand, my lord.
And
It's a
Mr.
case of
Vijay Kumar,
ignorance.
please understand.
Yes.
In every case, negligence, my vehicle is not involved. Thing is
Well,
like the matters, you have to balance everything.
I
And
understand, my
in
lord.
every
Wherever
case,
there is,
that can't be the argument. You're even pending matters like this. It is for your company to pay the interest
yeah, I
whenever the
understand.
amount is awarded.
I understand, my lord. But only thing,
That's
my lord,
why
is here,
what you
owner
have to
also denied the
know,
involvement.
Mr. Vijay Kumar, please
Ah.
understand. What I tell you is, in all the matters, instead of making those kind of arguments, straight away when you know that there is no point,
My lord,
if
in
you
many
if
cases,
you're
my
fair
lord,
to the court, listen. If you're fair to the court and come to the right point, then what happens is court will also understand, Mr. Vijay Kumar will argue where there is a point. Otherwise, if you start arguing like this, court will always be under the impression there must not be, there is no point, just like that he is arguing.
No, it
That's
is
why,
not like, my lord, it is-
please come to the point. That's what I want. That would be good for you
Definitely,
and
you
for
are,
the
you
other
are,
Para 30, my
I
lord.
fully agree,
Draw
my lord,
attention
I
to the
fully
para
agreed
30.
with your lordship. What your lordship is telling 100% correct, my lord, but I usually in many number of cases wherever there is no liability, where there is no
That
involvement
is
of
for
our,
this
I
court.
definitely I'll agree.
No,
I'll
Mr.
definitely I'll
Vijay
agree.
Kumar, Mr. Vijay Kumar, it is for this court to say that usually whether you agree or not. You can't
My
give
lord,
certificate to
my lord,
yourself.
my lord, in most of the
Any of
cases,
this
my
smart
lord,
will remand.
my,
When they are
the cases
denying the
which are
accident
adjusted
itself,
to,
will remand.
please,
Will
my lord,
remand.
please,
Unnecessarily, if it is the same argument is advanced, your time is unnecessarily, your client is losing the time.
I understand, my lord.
Please come. Agreed by the award passed in MBC number 1449 of 2021, dated 2nd September 2023, whereby the tribunal had granted compensation of an amount of rupees 5,26,300. The claimant is before this court seeking enhancement of the compensation by filing MFA number 7352 of 2023, and the insurance, the KSRTC.
No, my lord,
Not
it is
KSRTC.
appealed by the insurance
Yeah,
company.
Reliance General.
General
And
Insurance
the
Company.
insurance company is before
Yes,
this
ma'am.
court by filing MFA number 2277 of 2024.
My appeal is also there.
That I have already, first your appeal only I have dictated. The land counsel appearing for the insurance company submits that no notice was served on the insurance company, and the company is set ex parte and an order is passed. It is submitted that they're denying the liability, they are denying the liability on the ground that the vehicle is not involved, and even the owner of the vehicle has contested the matter. Learned counsel has across the bar has submitted that in several cases notices are not served on the insurance company, and still it is held that still the insurance company are held ex parte. In this regard, they have already given a complaint, and the same was addressed by the court. Considering the submission of the land counsel for the insurance company, for giving a fair opportunity to both the parties, this court deems it appropriate to set aside the award dated so and so and remand the matter back to the tribunal without further notice.
A time may be fixed, my lord, so
Just
that
wait. Without further notice, the party shall appear before the tribunal on 8th October. On 8th October, and within 6 months from the said date, the court shall consider and pass orders. And the outer limit of 6 months, the order shall be passed. The amount in deposit shall be forthwith transferred to the court and shall be deposited in a fixed deposit.
Much obliged, my lord.
Both the appeals. Accordingly, both the appeals are order is set aside and both the appeal remanded to them.
Cell number 34. Cell number 34.
Ravi Shankar CR, where is he? Give it some in the month of December.
December.
Yes. That Lok Adalat list has come. There only. How many matters, Pradeep, today? You have the list? Lok Adalat. That also they're going. Adjourned.
It's held up in the.
Give that next 24th date.
34.
Because other side is also not.
It,
At the request of land counsel, the insurance company list on so and so. You have no
petition.
idea.
The writ petition. The insurance company.
Petition. 24.
Sorry, Ola.
At the request of land counsel, the petition. You have no idea how many matters are there for the 20. Oh. And he said some more matters which were negotiations. You asked them? How many matters are there? What we do is Hmm. Not that. He is saying about fresh matters he has given, no?
This is Shivan Eloda.
The fresh matters what he has given, what you do is, basing on the work, all these matters, no, what you can do is, every day around, whatever is the list, every day around 4 o'clock, half of the matters, 10 matters a day, 10 matters a day, or list all these matters at 4 o'clock. What we can do on that day, we'll do it. All other matters will come next day. Will come next day. It will be going on. So we'll complete it.
Date will be fixed, Your Lordship, in this.
Yes, they'll give around 22nd or something. Whatever, basing on the work.
Much obliged.
24/9.
Much obliged.
ಇದೊಂದು ಡಾಟಾ ಶೀಟ್ ಪ್ರಿಂಟ್ ಕೊಡಿ ಇದು ಅಲ್ಲಿ ಲೋಕಲ್ ಅದ ಮುಂದೆ ಇವಾಗ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕು ಸ್ವಲ್ಪ ಇದು ಎರಡು ಕಳ್ಸೋದು ಆ ಕಡೆ ಇಟ್ಬಿಡು ಏನು ಆರ್ಡರ್ ಶೀಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ವಿತ್ ಎನ್ಸಿಆರ್ ಯಾವ್ದು ಸೀರಿಯಲ್ ಹೇಳು 33 ಅಲ್ವಾ ಸೊ ಇಲ್ಲಿ ಟೋಟಲ್ 18 ಒಂದು ಸ್ವಲ್ಪ ಕೊಡಿ ಇದೊಂದು ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಬೇಕು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲ ಮೇಡಮ್ ಇದು ಇವತ್ತಿನ ಮ್ಯಾಟರ್ ಲೋಕದಲ್ಲೇ ಮುಂದೆ ಅಂತ ಹೇಳಿ ಅವ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಮೆಮೋ ಅಂತ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅದೊಂದು ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಬೇಕು ಮೇಡಮ್ ಇವಾಗ 23 ಅದನ್ನು ಅಷ್ಟಲ್ಲಿ ಸೇರಿಸಿ ಫೈಲ್ ನಾನೇ ತರ್ತೀನಿ ಈಗ ಓಕೆ ಅದು ಲೋಕದಲ್ಲೇ ಬಿಫೋರ್ ಇವತ್ತಿನ ಡೇಟ್ ಹಾಕಿ ಕೊಡಿ ಫೈಲ್ ಆರ್ಡರ್ ಶೀಟ್ ಅದು ಇವತ್ತೊಂದು ಡೇಟ್ ಇದು ಫಾರ್ ಫೈಲಿಂಗ್ ಆಫ್ ಜಾಯಿಂಟ್ ಮೆಮೋ ಆನ್ 12/9 ಏನ್ ಸರ್ 30 ಅದೇ ಅದು ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಆನ್ 24/9 24/9 ಹೌದೌದು